sale of conjugal properties without the consent of another spouse under a valid marriage void or voidable.
If a marriage took place between 1950 and 1987, any sale of conjugal properties made by one spouse without the consent of the other can be invalidated at the request of the non-consenting spouse, but this annulment must occur within 10 years from the date of the sale. If no action is taken by the non-consenting spouse within the 10-year period, the sale remains legally valid.
In a notable legal case of 𝘃cieះ𝗀𝗏𝗹 versus 𝘃cie Bautista, et al., Gr. Number 2-46445, March 2, 2021, the Supreme Court interpreted the application of Articles 165 and 166 in relation to Article 173 of the Civil Code.
Based on its interpretation, the sale of conjugal properties without the consent of a spouse in a valid marriage between 1950 and 1987 is not automatically void, it is only voidable. The aggrieved spouse can ratify the sale through an action, and the action to annul the sale may become time-barred after 10 years.
On the other hand, if the marriage was contracted during the period when the Family Code, which became effective in 1988 and remains the governing law, any sale made by either spouse without the other's consent is considered void. The relevant laws in this case are Articles 96 and 124 of the Family Code.
In these cases, a void or inexistent contract means that it has no legal force or effect from the outset. However, there are exceptions when the sale is subsequently ratified by the non-consenting spouse or authorized by the court.
In conclusion, the legality of selling conjugal properties without the consent of a spouse in a valid marriage depends on the time of marriage and the governing laws.
For marriages between 1950 and 1987, such sales are voidable, and the non-consenting spouse can annul them within 10 years of the sale. However, inaction by the non-consenting spouse can ratify the sale, and the right to annul it may be time-barred after 10 years.
On the other hand, for marriages after 1988, under the Family Code, such sales are considered void, and they cannot be validated without court authorization or the written consent of the non-consenting spouse.
Exceptions to this rule may exist if the sale is subsequently ratified by the non-consenting spouse or authorized by the court. The specific legal framework governing the marriage date and the nature of the sale are crucial factors in determining the validity of such transactions.